Well, thank you all for coming. Um, I think this afternoon was mostly a party and a chance for some cupcakes with strange icons on them, but also a chance, I think, to explain a little bit more to some of the people around college uh, what the Quill Project actually does. Um, Somebody described the Quill Project to me as the college's cult, because everybody sees all of the activity around the college. But why today? Somewhat to my shock, earlier this summer, I realized it was 10 years ago that I sat in the cafe a few yards away and wrote the first code for what became the digital platform underpinning the Quill project. And I mentioned this to Ruth, who thought that we really couldn't let this 10-year anniversary go unmarked. And so thank you for everybody who organized activities today. And it was wonderful to see the students and people from actually around the university come down to find out more about some of the little sub projects. I was thinking what I should do for this talk. And I thought what might be best is just to take a step back and look at some of the high level aims of the project. I suppose the project is about agreeing to disagree, or rather, how we agree to disagree, and maybe more particularly, how we study how we agree to disagree. And that feels perhaps more important than it did 10 years ago. I think 10 years ago, when I was starting this project, it really did feel very much like an academic project. It was born really out of my interest in text and editing, and some quite niche scholarly questions. But in the meantime, the world has changed a little bit. Um, Roughly half of the population in surveyed countries, when this project started, thought that democracy was a good idea. Now that's still quite a low figure, um, but slightly depressingly, that figure has got smaller in the decade since. So dissatisfaction with democracy um, outweighs satisfaction with democracy in 12 major surveyed countries, according to a highly respected poll from this year. And in America, 62% of the population are dissatisfied with democracy, and in the UK, a little over half say that they are dissatisfied with the way democracy works in their country. A very good friend and colleague of mine has just won an enormous grant from the um, European Research Council to look into what might come after deliberative democracy. That's the world in which we live. Um, and just to zero in on one particular issue, um, whereas very close to 80% of Americans said that they trusted the Supreme Court, that is the guardian of the US constitutional text, back in 2005, that number has now plummeted to a little over half, with some demographics saying very certainly that they don't trust the Supreme Court. They don't trust the framework for written constitutions anymore. So what's that got to do with a digital project that sits in the corner of Pembroke's old quad? I think what the project is really about is this set of things. Um, Firstly, an idea that the process of deliberation, the process of disagreement matters as much as outcome. Most of the social science literature about constitutional design focuses very much on the design of institutions, the design of voting systems, the design of constitutional texts. Relatively little focuses on the process used to agree those texts. And the Quill Project is really a study of the processes that have written legislation and sometimes treaties and most often constitutions. I think the proposition of the project is that complicated processes need advanced tools to properly analyze them. And that's what the digital part of the project aims to do. I have resisted, for the purpose of this talk, too much technical detail. But there is a lot of technical work that has gone on behind the scenes to make the project work over the last decade. Another proposition of the project is that advanced tools and advanced editing approaches make existing archives more useful. A lot of the material that the team look at has been sitting more or less unstudied in state archives for 100, 150 years. And I think that the renewed interest in those archives is partly because the project is able to make them more intelligible. Another proposition of the project is that this should lead us to reflect differently on the nature of these texts. It's been rather nice. 10 years ago, I started talking about a negotiated text, and one hears that phrase used more and more now. We start to think of texts as the product of negotiation rather than individual authors. And I think also, and perhaps most controversially, one of the propositions of the project is that we need to think differently about at least some research in the humanities. As I'll go on to recognize, this project has involved round about 160 people, if my count is accurate, helping with various parts of the project. It really has been a collective effort. But I think, rather than dwell only on that as opposed to the sort of lone scholar approach in the humanities, there's another thing that I want to confront in this talk too, and that is what the humanities are even for. Ever since I was an undergraduate, it has been fashionable to say that history is not really about the study of eternal questions. This is a quotation in a book published by Cambridge University Press last year that quotes Quinton Skinner, a very famous Cambridge historian, saying that to demand from the history of thought a solution to our own immediate problems is to commit not only a methodological fallacy, but something like a moral error. I'm not sure that in a world where more than 50% of the population, perhaps 60% of the American population, no longer have faith in democracy, I'm not sure that in that world it is really acceptable to say that the old question of history, the question that historians have been asking ever since the discipline was first invented, that is, what is the best form of government? I'm not sure that question can really just be put to one side. And so the Quill Project does make one normative claim, which is that deliberative democracy is worth studying and worth understanding. And I draw enormous comfort in making that claim from the fact that it is what the founders of America also thought was the difference between their experiment in popular government and previous experiments that had failed. So Hamilton, writing under the pseudonym Publius, trying to explain to Americans why representative or why democratic government in America might succeed where other democratic governments had failed, said this: one of the things that marked America out as different from older experiments was the representation of the people in the legislature by deputies of their own election. And he didn't just mean assemblies that had an up or down vote on legislation that was put before them. He meant representative assemblies that could meaningfully debate and draft legislation for themselves. It wouldn't be a Quill Project talk if I didn't put this slide up. I've been putting versions of this slide up whenever I've talked about the Quill Project for at least the last 9 years, and I see no reason to stop now. And the point I always like to make is that it is much easier to imagine legislation as written by a lone individual rather than by a group of people. And so every generation has liked to imagine different constitutions as being principally the work of one or two minds, because it's just easier that way. And whereas our generation thinks of James Madison as the principal author of the Constitution of the United States, an older generation thought perhaps of George Washington. And here is a statue of George Washington in the pose of a lawgiver. And why not, in a way? George Washington is always depicted as a central figure at the convention. Those who wanted the convention to work knew that if he didn't attend, the convention was very unlikely to be successful and very unlikely even to meet at all. And Washington came under an enormous amount of pressure in the spring of 1787 to attend the convention. Even though when he was at the convention, he makes relatively few interventions. In fact, he only proposes, and then right at the end of the convention, one actual change to the text, because he was sitting in the chair at the convention and he felt that it would be inappropriate to express an opinion on the debates in front of him. Even as late as April, Washington very nearly didn't attend. He said, I see, or I think I see, reasons for and against my attendance at the convention, so near an equilibrium as will cause me to determine on either with diffidence. He didn't want to go to a process that was going to fail, and he saw enormous downsides if he turned up and the outcome of the convention was not a success. And one of the reasons that he thought that it might well be a failure is that there were simply two competing and apparently irreconcilable views about how the United States should organize itself. When we teach the convention now to school children, we like to put in front of them the Virginia plan and the New Jersey plan, and we encourage them to think about splitting the difference, that there are elements of one plan and elements of the other in the final text. That wasn't what it seemed like to contemporaries. One group of people in America wanted America to have a national government. They wanted it to have a sovereign national government. And the other wanted America to remain a loose confederation of states with an equal vote. Those are simply irreconcilable positions. And if the convention had done what we encourage school children to do when they look at this in their lessons and tried to split the difference, everybody would have walked out. There was no obvious compromise on the table. The other reason I wanted to look at these processes was because of a 1984 article that was very provocatively titled "The Creation of the Constitution, Scholarship at a Standstill." And what this article pointed out was that the records of the Constitutional Convention had been available for over 100 years. They'd been well studied, and there were essentially two views. One view, championed by Charles Beard, was the idea that the Constitution had represented some kind of almost counter-revolution against the radicalism of the American Revolution. And the other view was that it was a really good faith effort to establish Republican government for the United States. And what Hudson pointed out in this article was that for all the books that were written on the convention, very little had been done for decades, and I think since he wrote his article, very little would be done over the next decades to really alter that basic framework of analysis. And I wondered really whether there was something that we could do to think differently about the records of the 1787 convention, that would enable us in a way to cut through these broad narratives and think differently about the text that the convention produced. And I had always been very struck by this comment by Hamilton. I think it's probably the reason I was interested in American history at all. It's been frequently remarked that it seems to have been reserved to the people of this country by their conduct and example to decide that important question whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force. In other words, again, Hamilton is trying to tell the people of New York that one of the really distinctive things about America was the impulse to set up constitutions on the basis of a deliberative process, and then to put the results of that deliberative process to the people for a vote. This wasn't something that the 1787 convention simply made up. It had already been established in Massachusetts as the acceptable way of writing a constitutional text in the wake of the American Revolution. This two-step process of a deliberative assembly writing a constitutional text, and then that text going to the people for ratification. And if states tried to short-circuit either of those elements, the constitutional texts were not regarded as fully legitimate. That process of deliberation is something that older generations were much more familiar with than anybody living in the 21st century. People used to learn at school how to formally debate propositions to amend text, and would have been familiar, if they had sort of above average levels of education anyway, they would have been familiar with one of the manuals of parliamentary practice published on both sides of the Atlantic. I've just put a selection up there, but there are literally dozens and dozens and dozens of these textbooks, mainly designed for schools or for local debating societies or for local parties, to manage formal debate. And the thing that school children were encouraged to become familiar with was the idea of putting written propositions in front of a group of people and asking them to vote on them or proposing amendments to them in a formal process. This was a tradition of debate that ran all the way through the 19th century. It was familiar to many at the end of the 18th century. It drew upon manuals of parliamentary practice that had first been written in the 17th century, and it really remained part of the curriculum until approximately the 1980s, when many of these manuals cease to be published. But I was very interested in the fact that we were losing as a society our understanding of this way of proceeding, this way of managing difference, this way of agreeing to disagree. It is now not something that most people have ever experienced or are familiar with. I'm afraid, since this is a sort of 10th anniversary sort of lecture, there are going to be pictures of me looking much younger as we go through the lecture. So this is me looking 10 years younger, introducing the project 10 years ago. And what I was thinking about in the lecture I gave 10 years ago was what we could do to transform our understanding of Madison's notes of the 1787 convention, the diary with which most historians and lawyers are familiar, that charts the debates of the Federal Convention. It was a text, after all, that had been available to the public since 1840. It had been edited into its modern form in around 1910, in an edition that had been in almost continuous print since then. So what more could we add? What I hoped we could do is take the manuscript images and the transcriptions that were widely available online and start to think of the US constitutional text not as a single document, but as the product of a collection of decisions that had been taken on that text. In other words, map out the process and see whether our understanding of that process ended up producing the final text. And I was encouraged to think about this process partly because there were echoes in the documents themselves that those who took part in that process also reflected upon the nature of the compromises that they were making. So there is a moment when one of the delegates says that, well, I hope the convention will actually strike out language that we have already agreed, because that language was relevant to the text in an earlier stage, and now that things have moved on, we don't need it anymore. This was text related to how taxation would be apportioned between the different states. In other words, the delegates themselves were thinking that they might agree to things contingently and then later change their mind, so that in other words, you might agree to a proposition not because you really wanted it to end up in the final text, but so that you would reassure other people while you made other decisions. Well, when I said to people that what I wanted to do was a digital history project, I got a lot of pushback. And I think it's fair to just pause and think about the objections. There was a faculty mentor I had who told me that this project would be, to use his exact words, career suicide. And the objections were broadly these: that the records we had of these processes of constitution writing didn't capture enough detail. That what I was proposing we did, that is, think of the final text as the product of a series of propositions and decisions made upon those decisions, that there simply wasn't enough detail in the records that we had available. Another objection was that the convention, the 1787 convention, wasn't really that complicated. I asked a number of people who'd worked on these records for most of their career how many big decisions they thought there had been, and some people said, well, maybe there were sort of 20 or 30 significant votes. Others said maybe 100 or 200. Other people raised the objection that the records we had disagreed with each other, that Madison's notes and the official journal of the convention diverged, and it was really hard to rediscover what had gone on. And that because of the deficiencies of the record, we didn't really know when different clauses were agreed, and so it wouldn't really be possible to capture the sort of shape of the debates. Other people told me that we'd never get the technology to work, and other people said, well, legal history is no longer of interest to history departments. And other people said, well, if you're doing this because you're interested not only in the federal but in state records, just be aware there's nothing interesting in state records. That's why nobody's worked on them, people said. And it is true that some of these processes have terrible records. This is the Journal of the Massachusetts Constitutional Convention from 1780, and it's utterly clear that the secretary for this process was completely out of his depth. If you think that the job of the secretary at these conventions is to keep a very firm list of what has been proposed and what has been agreed, then you'll realize that a secretary who writes, the report was taken up and debated by propositions on which several amendments were proposed, some of which were accepted, does absolutely no good at all, because the secretary has failed in his basic task of actually keeping a record of what had and hadn't been agreed. But I think this was the exception and not the rule. And so in 2015 and 2016, we set out to try and see whether we could create a model of the 1787 Constitutional Convention. I'd written the database code and the document processing code in the spring and summer, and then Alfie Abdul Rahman, who was then a visualization postdoc working at the OERC, wrote the first version of the web interface. And you can just see in the background there of that first image, it really was a much less sophisticated platform at the time. All of the timelines were flat. There was no interesting visualization. It really looked very different to the platform today. And a recent graduate, Grace Mallon, worked through the summer on the records, reconciling the different accounts of the convention and putting into what was admittedly a very clunky system at the time, putting into that system her best effort to reconcile the different sources, proposition by proposition and decision by decision. And we booked a conference for the October of that year. I think the final data entry work was finished a week before the conference. And at the time, the platform took a long time to process the texts. So Grace had put in all of the propositions that were in the records, and I had this argument at the back of my mind that there were too many gaps in the record and we wouldn't end up with something concrete, and we left it to run overnight, I think about 3 days before the conference that we were going to hold. And the text that the platform produced was, in fact, the Constitution of the United States, which was rather nice. Later that year, we sat up late at night watching Donald Trump's victory in the 2016 election. And almost immediately afterwards, people started emailing, asking us to explain how it was that the convention had created a system for choosing the president where one could lose the popular vote but still win. And we put together a very quick collection of materials and put that online for people. This is not quite the set of statistics from the model that Grace built, but it's close enough. So the revised model of the 1787 convention shows the convention dealing with approximately 88 discrete pieces of paper of various types, on which about 1,000 amendments are presented, and making around 1,000 decisions in order to produce a text that is 2,500 words long. So this really captures for you, I think, the sense of detail that the convention worked with, even for that short text. And what that pilot project showed were the following things: that the records of the 1787 convention were much more accurate and complete than anybody had really thought. In other words, if you worked through them and edited them systematically, many of the gaps in the record that people thought existed simply proved not to be there. If you thought carefully about what the records were really saying, particularly in the light of the rules of debate, you really could, with a great deal of certainty, say when each clause had been brought up for discussion and whether it had been amended and how it had been amended. Therefore, a careful attention to the process of debate could make sense of apparent gaps in the record. I will confess that first year I wasted about 2 months working on a system that could manage discrepancies between the sources, because, again, I'd been warned over and over again that the sources simply disagreed. And so I thought that the digital platform would have to cope with a situation where Madison said that the proposals for debate read one way, and the journal said something else, and maybe Yates said something else, and so on. And so deep in the Quill code, there is some set of procedures to deal with that. We never needed to use them. So another null result of this initial study was that whatever might be written about the reliability of some of the sources, and whatever disagreements there are about the speeches that were given, or sometimes the sequence in which things were proposed, when it came to recording the actual words being proposed, there simply is no substantial disagreement, with one exception, which is that it's not clear in one place whether ex post facto or retrospective, in other words, whether Latin or English is used in one proposition. So not quite clear there. But one discrepancy in 3 months' worth of debate is almost no discrepancy at all. I think that pilot project had also showed that a sort of innovative approach to editing this kind of text could really yield some interesting results, and that we were able to work at speed. It had taken about 3 months to edit the records of the 1787 convention, which by any standards was very quick work indeed, especially with a platform that was in its infancy. I'm not going to dwell too much on all of the visualization that we ended up doing, but I do want to highlight the fact that an important part of the project has been to create a new visual language. And I think it's quite telling that actually when the team were putting together the sort of activities for this afternoon, the sort of icon set that we use, whether on cupcakes or on games for people to play, is what they went to. So we had to design a way of representing debate within a committee session, and this is what we came up with after quite a lot of arguing and trying different things that didn't work. I always wanted it to look a little bit like music, and I think this almost does. This is the shape of the convention agreeing the set of rules. So the very first thing that the 1787 convention does is agree a set of rules for it conducting its own business. And these were mostly not controversial. You can see this long line of propositions. Even if you've never used Quill before, maybe you can get a sense that all of those little square icons are individual proposals for rules that should be written in, and the little diamonds are mostly agreements, with the exception of one rule, which was a proposal that everybody's votes would be recorded in the minutes. And King raises an objection and says, well, if we record in the minutes who's voted for and against particular things, people won't be free to change their mind, and they'll be too worried about what happens when the minutes get published. And so that rule was rejected. But you can see from the shape of that, this is a very convivial, orderly process. If we just contrast that with the first day of debate, the first substantive day of debate on the 30th of May, without even looking at the text, maybe you can get a sense that things have started to go wrong. What looks like a sort of orderly beginning to debate degenerates into a situation where very little is being agreed. And that's because on this very first day of debate, Hamilton and Madison get into an argument about whether the representation in the national legislature to which states are entitled should or should not benefit slaveholding states. It very nearly derails the convention just at that moment. You can see again on Wednesday, the 20th of June, a short period of debate at which almost nothing is agreed. And then the following day, on Thursday, the 21st of June, an even more disruptive outline. And if you actually look at the agreed text, in other words, if you look at the text that had actually been agreed by everybody by the end of that Thursday, this is some way into the convention, only 2 lines of text had been agreed. So they have a very long way to go. And I think what this highlights is really just how difficult it was to reach any kind of consensus at the convention. I've always rather liked the records for Thursday, the 28th of June. Again, a very short visualization, which tells you that there was almost immediately an argument, and they almost immediately had to adjourn. And the very first thing that happens that day is that one of the delegates proposes removing one word from one of the clauses that they've agreed. So clause 7 at that point read, resolved that the right of suffrage in the first branch of the national legislature ought not to be according to the rule established under the Articles of Confederation. This had been a point of contention now for weeks. They'd managed to agree that text, and somebody says, well, I want to revisit it. I want to take out that word, which of course reverses the decision that they've taken. And what happens immediately is that Franklin proposes amending the orders of business so that a priest would be brought in every morning to say prayers to help the deliberations. But that proposal to amend the orders of business fails for a number of reasons, but partly because they realize they don't have any money to pay a priest. But if we then look at the end of the convention, what we see is that everything has settled down again. And I'm deliberately just focusing on the visual language. You can see everything looks a lot calmer. This is the final set of amendments proposed to what was, in fact, the final draft of the Constitution. The final draft that had been through all of the different committee cycles was now sitting on the table of the convention. And it wasn't just a pro forma exercise. There were amendments proposed even at this point, some of which succeeded and some of which failed. But you can see just in the visual language alone that everything has calmed down. A consensus has emerged. This is a text that people are going to live with. The tool we built that I think is most innovative doesn't have yet a really good graphical display. But one of the things that the platform lets you do is discover when a phrase was proposed or debated or agreed to or removed or amended. And this lets you discover in a way that a word search in the minutes never could, the way in which clauses have come into being in the final text. And if you haven't played around with the phrase search in the Quill platform, I really encourage you to do that. This is the tool that I use almost every day when I'm looking for the history of particular phrases. Well, we did that pilot project, and then we thought, what next? So we thought we'd go and look at a state convention. And we'd done a little bit of work with a university called Utah Valley University. And so it seemed natural to ask the students there to go into the state archives and see what the state of the record was for the 1895 Utah Convention. And that turned into an 18-month project to edit those records that was mainly student-led. We didn't have an editorial team at Oxford properly in those days. And that convention surprised us. Because again, everybody said, no, state conventions are really straightforward. Everybody knows what a state constitution needs to look like. State constitutions are not very interesting. That's why nobody's paid attention to the records. Well, the students went in and started doing the work of digitizing some of them, transcribing some of them, and putting them together in the Quill timelines. And if you look at the numbers, it's actually more complicated than the 1787 convention. So hugely more complicated committee structure, huge number of documents, 650 committee reports or other documents that are being considered at different times, and around 2,000 decisions taken by that convention. And that state constitutional process is part of a huge tradition of constitution writing in America that is almost completely overshadowed by the fact that the federal constitution changes so little. So these are just the stats, for example, for constitution writing before the Civil War. So between 1776 and 1861, 70 constitutions were written for American states, almost all of them through a convention process, some of them through a looser legislative process. That doesn't include the constitutions of the seceding states, nor 9 constitutions adopted by native peoples, also some of them through some kind of convention process. And since 1776, there have been around 235 constitutions written from scratch or by conventions with plenary powers to change constitutional texts completely for the American states. And then those constitutional texts have been further amended literally thousands of times. So there really is a tradition of constitution writing in America that ran from 1775 through to 1986, when it was almost completely replaced by non-deliberative processes, that is, by the ability to put constitutional amendments directly on the ballot without any kind of deliberative process. I want to talk just a little bit about some of the other projects that we've done. So with Utah Valley University, there have been 2 major grant-funded projects. One of them called Constitution Writing in the American West, which was funded by the NEH. And then the project that they're now working on, funded by a National Archives grant, for constitution writing before the Civil War, looking at constitutions written in the 1850s, which are still in effect, which are still the basis for government today. I'm also incredibly proud of these 2 projects. On the left, there's the Civil Rights Amendment project. So that's the 13th, 14th, and 15th Amendment. These are the constitutional amendments written around and in the wake of the Civil War, and including the 14th Amendment. Now, if you have ever followed any major constitutional controversy at the United States Supreme Court today, it probably has something to do with the 14th Amendment. So this is incredibly important to understand. This process of drafting the 14th Amendment really is probably the most important and perhaps least studied set of clauses in the American Constitution. There's a case that will be decided by the Supreme Court this year on birthright citizenship, which is one of the things that the 14th Amendment talks about. This collection was put together during and immediately after COVID. One of the things about it that made it tricky was that, unlike most of the projects that we do, where if you're studying a constitutional convention, there is a discrete record set, and you just put all of it online. The work of Congress is not like that. If we had tried to put 10 years worth of congressional debates online, we would still be working on it now. So we had to be selective. But we couldn't simply look at the successful resolutions for constitutional amendments, because they interacted with the debates for many things that didn't succeed and for many other pieces of legislation. And so this collection is rather different to most of our other collections in the sense that it is selective, but broadly so. So we aim to include other relevant pieces of legislation that help you understand the debates on the 13th, 14th, and 15th Amendments. The other thing was that we didn't really want this to be a triumphalist story. So the collection starts with the story of the original 13th Amendment, which would have entrenched slavery forever in the Union and was actually passed by Congress but not ratified before war broke out. And it ends with the Civil Rights Act of 1875, which was ultimately struck down by the Supreme Court, although the text of that act is the basis for the successful acts in the 1960s. So there is a successor project to do at some point looking at those later acts. And the other one on the right is another project which tries to contextualize something. And this was a passion project really by one of the students at Utah Valley, looking at the 19th Amendment, but the debates on the 19th Amendment are not in and of themselves very interesting, because the text of the 19th Amendment, which is the amendment that gives women the vote, is very static for years and years and years. It just keeps coming up for debate and keeps being voted down. But we twinned it with the Edmunds-Tucker Act, which is an act that actually removed the right of women to vote in the Utah Territory, as well as taking other measures against the Mormon Church. And it provides a really interesting context for some of the debates about the rights of women to vote. There's perhaps a sense that you've got, listening to me talk about all of this, that there was a bit of mission creep in the project. So that the 1787 material relied upon records that had been well edited for about a century before we started to look at them. But most of the subsequent projects have not been in that happy position of being able to rely upon texts that have been well edited. And so a lot of the work that the project now does involves scanning and transcribing records and actually organizing them into new collections. So this is one of the biggest of those projects. This is a picture of the Illinois archives that relate to the 1960s state convention in Illinois. We haven't even, I would have said, got halfway through that project, because there is so much to do just at this sort of organizing stage. What about some conclusions from some of our projects? Well, a project that I think we're very fond of is the project that we did with the University of Western Australia. We're just in the final year of that now. And that project is a wonderful example of how one clause can be a sticking point. Full disclosure, this was a point that the team asked me to make in this lecture, as we sit in a government shutdown situation in the US, where the Senate is refusing to pass a bill that's been passed by the House. Well, the Australians worried about this problem for the better part of a decade, and have a very long provision about how to deal with this situation. And it went backwards and forwards. I am reliably informed that there are more than 200 pages of debate related just to the text that's on the screen. One of the biggest projects I think we will ever do was an AHRC-funded project that's just finished, looking at the drafting of the Constitution of India between 1946 and 1949. And again, I've put some of the statistics related to this project up on the screen. But Lauren, who was the lead editor on that project, worked through 9,783 separate proposals to amend text. Really a remarkable body of work. That project also reminds us that people don't always write constitutions for the same reasons. There are sections of the Indian Constitution that are explicitly not enforceable in court, that are simply aspirational statements put into the text in order to encourage people in government to behave in particular ways. And I think that reminds us that these processes are not simply about drafting a text, they're also about investing it with a certain amount of moral authority. That if a group of people have met and drafted a text in this formal way, it's supposed to carry weight, especially if it's then been ratified by the people. So this is not, these texts, these constitutional texts are not simply about providing mechanisms for people to seize power. They are also ways of holding people to account, even if only morally, once they're in power. Another project that I really want to dwell upon for just a minute or two is the Writing Peace project. I think one of the most remarkable pieces of work that we've done and led by Ruth Murray. It's remarkable not only for the sort of application of the technology to understand the process of negotiation, but also for the way that we've been able to bring different archives together from different communities in Ireland. And so one of the tools that we've been building for this project that will actually roll out to the American projects too is a tool that actually tracks where papers are held. Even if we don't hold scans of them ourselves, we aim to be a one-stop shop for people to at least find out what is available related to the peace process. And I think that, again, is something that 10 years ago, I didn't think we were setting out to do, but which has proved to be one of the really important things that a digital project can do, so that virtually at least we can bring these archives into conversation with each other. This project too has some material that we've digitized and some material where we're simply linking to material that others have digitized. It's a project as well that forces me to confront these two extremes. The lawyers, this is Blackstone's dictum, the fairest and most rational method to interpret the will of the legislature is by exploring his intentions at the time. And note actually that he's thinking of a lawmaker as a single individual rather than a group. Versus, this wonderful phrase, constructive ambiguity. Most of the processes that we look at nail some things down very tightly and leave other things rather vaguer as the price of getting agreement. And sometimes not everybody agrees which is which, even if they've been part of the process. And in some cases, people can't even agree to disagree, and can't even agree about how they're going to disagree either. So Minnesota accidentally ends up with two constitutional conventions running in parallel that end up having to reconcile their work, and that's a project that's coming to conclusion soon, and I'm excited to see how that process of reconciliation works at the end. One of the things we have not looked at so far are processes that really fail outright, but it would be interesting to look and see whether there is something about processes that work versus versus processes that don't work. Another area that, again, 10 years ago, I didn't think we would be working on quite so much, but which has proved to be really important, is classroom materials, again, mostly developed by our colleagues at UVU. Just in the last couple of years, working with teachers in America over the summer, we've really found a way of bringing this material alive for the classroom, and that's been really wonderful to see, because it's helping to train a new generation to think about these constitutional texts in a different way. So I published a rather more technical lecture about this project a couple of years ago, and a rebuttal appeared in a journal, making the following complaints. there was a dearth and unsuitability of records to describe state constitutional development. Respectfully, I disagree. There is a huge category of material out there to be edited. The criticism we often get is, well, it's all very well to focus on these formal processes, but surely a lot of conversations happen in private that the records don't capture, to which I say, well, of course that's right, but we can at least be rigorous about the process that has left us with particular texts. And thirdly, that the project will lead inexorably to originalist interpretations of constitutional provisions, to which I say I'm a historian and that's really not my department. Our technology stack has definitely grown. So we started thinking just about how to represent this process of debate. We now track, as I've said, where archives exist and what is in them. We look at providing world-class digitization and transcription where we can, and we're still developing our tool set for that. Of course, at the core of everything we do are the models of debate that we have. We're looking at cross-indexing topics between documents and between negotiation processes, because it's quite clear that there is a global conversation about these constitutional texts, and different processes borrow widely from each other. We host annotations and discussions of the material, and we also host classroom materials. So if that's the last 10 years, what are the next 5 to 10? Well, these are my priorities. There are 50 currently operative state constitutions in the United States. I would like to see us make sure that we have captured as many of those as possible, if not all, or as many of the processes that drafted those constitutions as possible. I think it's especially important that we look at creating a founding era constitutions collection, capturing constitutional debate between 1775 and 1790, because that is a period when the states were debating bills of rights, and those debates ought to help us understand the language of the federal text itself. And for much the same reason, an early states constitutional collection running from 1790 to 1836, which is the last time anybody involved in writing the 1787 Constitution was present at a state constitutional convention. That was the period understood by early Americans as being the most important for determining the meaning of the federal constitution. The Ireland project has become one of our flagship pieces of work, and I really want us to finish that work and take it at least down to the Good Friday Agreement. And I think we're going to need to develop comprehensive classroom resources. On the technology side, the existing technology is written very much for historians, and it's quite clear that we need to develop the tools that lawyers need. They have slightly different concerns. And classrooms, too, are pushing us to change some of the ways that we present material. But I got told last week that I should distinguish more clearly between outputs and outcomes. So what about outcomes? Because I started with this rather depressing statistic about people's faith in the democratic process. I think these processes of negotiation over the last 200 or so years are really important to study. There have been hundreds of them. They've been part of a global conversation about rights, and I think focusing on that is really important to push back against some of the rhetoric that you see that says that human rights are a Western imposition. Lawyers, of course, will do what lawyers do, but I think there is a story for the rest of us as well about better understanding how democratic institutions have been created, how has institution building happened, and so on. Ultimately, I think we need to reassure a skeptical younger generation that has grown to distrust the products of compromise, to distrust institutions created by deliberative processes. And I think they need a certain amount of reassurance that these processes did indeed produce institutions that No, not perfect. And yes, definitely institutions that need to be renewed from time to time. But to come back to my normative point, institutions that remain, I think, one of the best ways to govern society. So I'm thrilled that we have a group of students every summer now coming to Oxford to study constitutional history. I hope that some of those students will go on to do PhDs and research in this field. You've probably picked up all the way through this talk that many, many people have been involved in the Quill Project, and I want to pay huge tribute to the editorial team for really pushing our methods forward. Um, a lot of the way that we think about how we use the technology and how we edit text consistently has been driven by a really, really committed editorial team in Oxford and elsewhere, thinking about the best way to represent these processes. And it's complicated and difficult work, and um, I've been really lucky to work with people who've been incredibly dedicated to getting it right. I think the most terrifying moment of the last 10 years was a press conference in Arkansas, where suddenly I realized that they were going to do a live demo of the Quill platform in support of a huge grant by the Attorney General to one of the universities there, with the aim of getting the state's constitutional history completely mapped out over the next few years. And as nobody had warned me there was going to be a live demo, and if the conference room Wi-Fi had failed at that moment, I think the whole thing would have been off. And lastly, a hope for the future. There's a picture of me with Rod Smith at Harvard University a few years ago, trying to persuade some people there that some of this material needed to go back onto the curriculum that it had fallen off of. I could say thank you to many, many, many people. This project has only existed because of the very kind support of people who have not given me permission to name them publicly, and so I won't, but they know who they are, and a huge number of people who've worked on the team. And it would be awful to only name some and not others when so many people have put so much in. But there are two people that I really need to say thank you to in closing. Ruth Murray, who's now the deputy director of the project, who absolutely hates having her picture on anything even more than I do, and so I will definitely pay for this later. But Ruth, thank you. I couldn't have run the project over the last few years without you, and thank you truly. And then Scott Paul from Utah Valley University, who's managed one of our key partnerships. In fact, our strategic partnership with that university, and has shepherded us through 8 or 9 years of really interesting work with the students out there. I hope that's given you a flavor of the project. I hope that's given you a sense of why I think it's important. And with that, I will stop. But thank you for coming to our birthday party.